Ladies and gentlemen, let us all rise for the arrival of the Honorable Senate President and the Senators of the Republic of the Philippines.
The 53rd session of the Senate in the first regular session of the 18th Congress is hereby called to order. Senator Christopher Lawrence Go will lead the chamber in prayer.
Let us put ourselves in the holy presence of God. Lord Almighty, The start of the year has been very difficult and trying time for our nation. While a part of us is still recovering from the effects of the natural calamity, another threat is also besieging us from abroad. Lord, thank you for giving me the opportunity to serve our people and to work with my fellow senators here in the Senate. To my fellow senators and public servants, we only pass this way but once. Any good that we can do or any kindness we can show to any human being, let us do it now. Amen.
Amen. The Secretary will please call the roll.
Roll call of members, the Honorable Senators Angara, Binay, Cayetano, De Lima, De La Rosa, Drilon, Gatchalian, Go, Gordon, Ontiveros, Lacson, Lapid, Marcos, Pacquiao, Pangilinan, Pimentel, Poe, Recto, Revilla, Tolentino, Villanueva, Villar, Zubiri, Senate President Soto III.
With 17 senators present, the chair declares the presence of a quorum. Majority Leader.
Thank you, Mr. President. Mr. President, I believe some of our colleagues would just like to stand up to make a quick manifestation before we approve the journal tomorrow, journal of yesterday's journal, rather, Mr. President. We'd like to recognize
All right.
Senator Tolentino, Mr. President.
Senator Francis Tolentino is recognized. What is the pleasure of the gentleman?
Mr. President, just a manifestation relative to Senate Resolution number 312. Mr. President, had I been inside the session hall yesterday, I would have joined Senator De La Rosa in voting for abstention, Mr. President. And with the permission of this honorable body, allow me, Mr. President, to explain why I would have abstained in yesterday's vote.
Why you
Mr.
would have
President.
abstained? Yes,
Yes,
go ahead.
Mr.
Go ahead.
President. Mr. President, relative to the visiting forces agreement, which from news reports reaching this representation was already officially terminated with the notification coming from the Department of Foreign Affairs Secretary. Let me explain my vote. The acts of each branch of government must not be controlled by or subjected to the influence of either branch because, Mr. President, such is the essence of separation of powers. My vote relative to Resolution 312 would have been to abstain, as mentioned earlier. Our republic is a sovereign and democratic state which is founded on the will of the people, which in turn endows our government with its vast and awesome powers. Maintaining their balance is the time-honored principle of separation of powers, which is enshrined in our 1987 Constitution, Mr. President. Now this principle was put to test, or is being put to test once again, as the country grapples with the recent developments in foreign and national security policies relative to the Visiting Forces Agreement, or the BFA. We are not, Mr. President, yesterday or today, we are not voting here for the retention or abrogation of the BFA. We are not voting here to determine whether the BFA is beneficial or detrimental to the country. What is at issue here is the separation of powers among three co-equal branches of government to maintain the balance required by the Constitution. Does the President have the power to abrogate a treaty under the 1987 Constitution? I say yes, Mr. President, considering the President's role as the chief architect of our nation's foreign policy. This includes the decision to terminate the existing Visiting Forces Agreement, a political process with regional and international consequences. This goes into the very essence of executive power, which is in Article 7, Section 1 of the 1987 Constitution, and is vested in the sole person of the President of the Philippines. The Constitution, Mr. President, is enduring and upon its inception is intended to exist for ages. It governs the rights and obligations of the people, not only at this time or at the time of the framing, but also the far-reaching future. Its permanence protects the stability of fundamental rights and liberty. To quote President George Washington in his farewell address on 19 September 1796, and I quote, "The Constitution which any time exists, till changed by an explicit and authentic act of the whole people, is sacredly obligatory to all." It is without question, Mr. President, that by constitutional fiat and by intrinsic nature of his office, the head of state is the sole organ and authority in external affairs of the country, as the Supreme Court declared in Bayan versus Zamora, GR 138570, and Pimentel Jr. versus Executive Secretary. The U.S. case of Myers versus United States in 1926, 2722 U.S. 52, is instructive, as it tells us that Congress' power to remove or the right to participate in the exercise of a power given to the executive would infringe on the constitutional principle of separation of powers. The deference we give to the executive department is dictated by the principle of separation of powers. This principle is one of the cornerstones of our democratic government. It cannot be eroded without endangering the government, as stated by the Philippine Supreme Court in Secretary of Justice versus Lancion, GR 139465. Although the unilateral withdrawal from a treaty by the President is an apparent vacuum in the field of Philippine law, this has been done before in other jurisdictions. In a long line of cases, the United States dealt with the question of unilateral withdrawal in Goldwater versus Carter, 444 U.S. 996, on President Carter's termination of the Mutual Defense Treaty with Taiwan. In the case of Beacon Products versus Reagan, 814 Federal Reports 2D on Reagan's unilateral termination of the Treaty of Friendship with Nicaragua, and Kucinich versus Bush, 236 Federal Supplement 2D1 on the U.S. withdrawal from the 1972 Anti-Ballistics Missile Treaty. All these three cases ruled that in the light of the absence of any constitutional provision governing the termination of a treaty and the fact that the different termination procedures may be appropriate for different treaties, the instant case, among others, must solely be controlled by political standards, and therefore the challenge to the President's power vis-a-vis treaty termination raised a non-justiciable political question, Mr. President. Other prominent examples of unilateral withdrawal from treaties included the withdrawal of Indonesia from the United Nations in 1965, of Czechoslovakia, Hungary, Poland from UNESCO in the 1950s, of the Soviet Union and 8 Eastern European states from the World Health Organization in the same period. Even more recently, President Trump of the United States also withdrew from the Iran nuclear deal and the Paris Agreement on climate change. In sum, states have always operated in purview of their national interest and have withdrawn from international agreements without congressional interference. Can the Senate inquire, then, into the President's wisdom to abrogate a treaty? Mr. President, while I am of the opinion, collectively with the members of this chamber, that we should strengthen the powers of the Senate relative to foreign affairs, the reason why this is solely lodged with the President is by virtue of the Constitution and by reason of his office, that the President has access to the almost comprehensive and confidential diplomatic information and ultra-sensitive military intelligence data. What then is the Senate's role in treaty making? Section 21, Article 7, Section 25, Article 18 of the 1987 Constitution requires Senate concurrence to bind the state to such agreements. However, there is no similar provision requiring the same to abrogate a treaty. Our obligation lies not in the termination of treaties and international agreement, but in its creation. Requiring Senate concurrence in instances of abrogation is to create an obligation where no such judicial precedent or law exists. The constitutionally enumerated powers of Congress, Mr. President, circumscribe its authority to the exclusion of all. Expressum facit cessari tacitum. Mr. President, by interpretation or instruction, this may not be extended. To the members of this august body, I end this manifestation, albeit with sadness. Baka po sa mga darating na araw, wala nang tutulong tayo sa pag merong disaster, pero ganyan po siguro talaga ang tinatadhana ng ating saligang batas na dapat manaig ang desisyon ng Pangulo. To the members of this august body, I end my manifestation with a quote from George Washington as an allegory to our current predicament. And I quote, "It is important that the habits of thinking in a free country should inspire caution in those entrusted with its administration to confine themselves within the respective constitutional spheres, avoiding in the exercise of the power of one department to encroach upon another." Sana po ang yugtong ito ng kasaysayan na sa palagay ng iba ay mahirap sa kanila o mahirap sa hinaharap ay malagpasan natin sa tulong ng poong may kapal. Maraming salamat, Mr. President.
Motion to adopt. The minority leader is recognized. Senator Dillon.
Yes, Mr. President, the manifestation of the good gentleman from Cavite compels us to make likewise a manifestation in that regard. Mr. President,
Again, sorry, minority leader.
Mr. President,
Yes.
the issue of whether or not the Senate concurrence is needed in the withdrawal of a treaty is precisely pending before the Supreme Court today. It is an open legal question. The good gentleman cited jurisprudence in America wherein the Supreme Court ruled that this is a political question. In our case, in our Constitution, the Supreme Court cannot shirk from that duty to interpret the acts of the different departments of the government on the ground that it is a political question. It is our submission that this is an open question. Second,
in fairness to the minority floor leader, can we ask for our colleagues to refrain from conducting little discussions? Because, well, the good senator from Cavite was discussing, I almost stood up, but there are important matters that we're discussing here, and I would like, out of respect for, not only for our fellow members, but because it's a vital issue that we're discussing today, to focus on the issues, Mr. President. This is not a partisan issue, Mr. President. This is an issue that involves national sovereignty, it involves defense, it involves our territory, it could involve many things, and that's why
The
I'd
most
like to listen
important-
to the minority floor leader.
And
My
most
motion,
important of all, it involves the Senate.
yes, Your Honor.
All right, minority leader.
thank you very much, Mr. President. As we said, this issue, the Supreme Court of the United States refused to review acts of the executive branch on the ground that the concurrence of the Senate or of Congress in the withdrawal from a treaty is a political question. In our present system, the fact that it is a political question does not provide a justification for the Supreme Court to shirk from that duty and obligation to interpret the acts of the political arms of this government. As we earlier stated, there is a pending case in the Supreme Court involving the withdrawal from the Rome Statute. And let me point out, Mr. President, that in about 25 resolutions in the 17th Congress, this Senate has included in the concurrence in the ratification of the treaty a provision which says that the concurrence of the Senate shall be secured to make the withdrawal effective. If there is any sense of the Senate, that is so expressed in these 25 resolutions, and this has, in our view and our submission, Mr. President, has a legal binding, legal and binding on the political branches of the government, because the Senate is a partner of the President insofar as treaty making is concerned. So it is our submission, Mr. President, that the fact that the United States and another jurisdiction, the decision has been that the that it was considered a political question is not relevant to our discussion. We strongly submit that in our case, the Supreme Court will have to rule on this, and that the sense of the Senate was manifested in 25 of the resolutions in the 17th Congress, wherein we agreed on a provision that any withdrawal from the treaty should have the Senate's concurrence. Thank you very much, Mr. President.
All right. Senator Gordon?
Mr. President, would the gentleman pardon me if I ask him to continue to stand, because I'd like to ask him a few questions, if I may. Yes. The gentleman is the minority floor leader, and he's, I suppose, stating...
Yes, that is completely in order, because
Yes, ma'am.
he has the floor, he stood up, and anybody can question anything that he has said.
Thank you, Mr. President.
Yes, Mr. President, willingly.
Mr. President, the gentleman of the minority floor leader has stated that the Supreme Court has the duty, the responsibility. It cannot shirk from its responsibility. And so far, the prevailing view is that it is a political question.
That's a jurisprudence cited by the gentleman from Cavite insofar as courts outside of the Philippines are concerned, citing specifically the U.S. Supreme Court, where the U.S. Supreme Court refused to touch upon a ruling of the lower court on this issue of withdrawal because it is a political question.
That is correct, Mr. President. But even in that Supreme Court, there were positions made by Justice Powell. Justice Rehnquist said this is a political question. Justice Powell said it is not. Even in the case of Sagisag versus Ochoa, Mr. President, he said, our Supreme Court said, it is not an absolute prerogative of the President not to include the Senate if it is going to abrogate an agreement. Would you agree with that, sir?
Yes, Mr. President. In fact, that is reflected in the sentiment of the Senate, with it included as among the conditions for the concurrence of the Senate in the ratification of the treaty, that any withdrawal from the treaty should have the concurrence of the Senate.
Now, Mr. President, let me just go for the purposes of the gallery as well, and I'm not playing to the gallery. Mr. President, in the wisdom of all in 1935, as well as in today's Constitution, it says that any treaty must be ratified by 2/3. And the reason for that is that when you engage into a treaty, Mr. President, I'm willing to keep quiet so that they can continue their conversation, if I may. Now, Mr. President, thank you. I'm sorry. I mean, I'm very passionate about this thing because I think it involves our national sovereignty, our defense, our people who could go into harm's way, and we are in a situation where any move that we do could affect that, Mr. President. So, would you agree with me that the reason why they had 2/3 vote is so that the co-equal branch of government, the Senate, will be part of a collegiate group, so to speak, and that's stretching it a bit, na dapat papakinggan ang Senado at tayo lang, hindi lower house, ha? In the Constitution, tayo lang ang nilagay doon na Senado ang siyang magra-ratify ng agreement. And that is because of the issues aforestated. These are matters of national interest, national sovereignty, national defense, and national territory. Tama po ba yan?
Yes, sir. The traditionally recognized prerogative of the executive branch in the conduct of foreign policy is qualified by the participation of the Senate, and that participation is in the form of concurrence in the ratification of treaties and, Mr. President, in the confirmation of ambassadors of the Philippines to foreign countries.
Now, yesterday, Mr. President, we had agreement here in the position that the ultimate steersman of foreign policy is the President. But we submitted that it is not an absolute, because that's why you had your resolution 3 years ago that says all treaties must pass through, because that is the intention.
Yes.
That is the intention of the Constitution.
Yes, Mr. President. In fact, when this chamber did not act on that resolution, we had the individual concurrence contain that condition, and that was approved unanimously.
That's correct, Mr. President. Now, Mr. President, in the matter of the American case, Mr. President, there was that position by Justice Powell, as if concurring with the later position of Ochoa, or the case was against Secretary Ochoa, that says there must be, he didn't say this, but it comes to me as there must be an overt act by the Senate to protect its prerogatives, to continue to be part of the conversation. Meaning to say, the President cannot just terminate because you asked permission to have this agreement, you had the Senate agree with this position, but you just cannot terminate because the same issues taken up when you were approving the agreement is now the same issue that you will have, and perhaps some changes have already occurred. At that time, we had no threats from our neighbors. At that time, our territory was not being taken. At that time, our ships were not, our boats were not being rammed. And so, Mr. President, would you agree that therefore there is a position that the position of Justice Powell and the position of Ochoa would now be timely for the Senate to say, maybe if the President doesn't change its course, and quite frankly, I am kind of confused at the Panelo saying we have issued, and then later on, Secretary Lorenzana says, no, there is no issue, and then finally, there seems to be confusion. And having said that, it behooves the Senate of the Republic of the Philippines that we stand up and say, ano ba talaga? Kung yan na talaga ang sinasabi ng Pangulo, we have the duty. The gentleman, the minority floor leader, was saying, the Supreme Court cannot shirk from its responsibility. Yesterday, I extolled the President of the Senate for saying, we have a say in the conversation. There are 3 branches of government. Kailangan kukonsultahin nyo kami. And now, Mr. President, gumalaw na ganito without attacking the President, sharing what the President feels right now, the Senate must now do its duty as part of the co-equal branch of government to create what you might call a justiciable position, a justiciable situation, I'm sorry, not position, where if we keep quiet, it remains a political question. Would you agree with that, sir?
Yes, sir.
Now, if you agree that it is a political question, if we do not say anything, when we take a position saying, this is our position, Mr. President, we would like to disagree with you. We would like to know what are the fundamental reasons why this change of position is taken. And we have the duty also to make sure that we don't shirk from our responsibility and tell the Filipino people we disagree with the President, and therefore now there is a constitutional issue that can now be brought to the Supreme Court of the Republic of the Philippines, Mr. President. Would you agree, Mr. To the minority floor leader?
Yes, Mr. President. In fact, 3 years ago, we had a resolution signed by 14 senators expressing the sense of the Senate that any abrogation of the treaty must carry the concurrence of the Senate. Unfortunately, that resolution was not acted upon. So there were, in the subsequent action of the Senate on each specific treaty, there was a clause which imposed this condition that any withdrawal from the treaty should have the concurrence of the Senate. In fact, this is a stronger provision that dissents of the Senate, because it is part of the ratification or the concurrence itself, Mr. President.
And really, first-year law, when somebody is given a right to approve something, when the facts change, if there is an implied right, and it doesn't have to be expressed, that the same people can obviously take a position, express its sense, and even question it to the Supreme Court, especially if it comes out with a positive response, such as a resolution saying that, indicating our position on the matter.
We agree, sir.
Sir?
We agree.
Okay, sir. In that case, Mr. President, the debate really is leading towards that position, because we don't want to go into lock horse with the President, because we agree, you are the helmsman. I don't believe you are the oarsman, but we sail the same ship of state, Mr. President. And therefore, we must have a say, especially on this important matter. Thank you, Mr. President.
Thank you.
Majority Leader.
Yes, Mr. President.
Senator Marcos, Senator Amy Marcos, recognized.
Yes. I would like to know if a vote was recorded on my part.
Yes, from yesterday's on the resolution 312.
Yes, I would like for
Yes,
that vote.
because there was a motion to adopt resolution 312. That means a vote, obviously. And so we asked for an objection, nobody objected. We adopted the resolution, and therefore it was voted into. Now, all those counted voted for the resolution were those who answered the roll call. And then there was one abstention recorded by Senator De La Rosa. That is the situation of the resolution 312.
Thank you very much, Mr. President. May I therefore, having been recorded as voting in the affirmative, reconsider that vote under our rules where it's allowed in the next 2 session days? I
Yes.
did not at any point vote. That is the actual status. And the passage of this resolution was without our knowledge that the vote was in fact taken.
Mr. President,
That is not the fault of the leadership of the Senate. You were not in the hall.
I was in the hall, Mr. President.
Then why did you not object?
because Senator Bato de la Rosa abstained.
Senator De La Rosa abstained.
Yes, he stood up to abstain.
If you were in the hall, you should have objected, or you
I was
should
not
have
aware that the vote was in fact taken because there were only 8 of us in the hall and no quorum was in fact present to establish a voting procedure.
That is not true, because once the roll call has been called and there is no roll call thereafter, that is a continuing,
continuing.
implication that there is a quorum.
Until somebody.
Somebody should have questioned the quorum in that case.
That's correct.
Next time, stay
procedurally.
in the hall.
Mr. President.
As I said earlier,
Mr.
po, I
President,
was actually in the
proper
hall.
motion,
Yes.
just to read the rule, Rule 33 of our rules of the Senate. Section 91, any senator voted with a majority may move for the reconsideration of the measure. She's absolutely correct, Mr. President. But she has to move for the reconsideration of the measure and not her vote. And therefore,
Yeah.
that is the proper order that they make. And
All
only
right.
those who voted in favor can do so within the next 2 days.
So
with,
everyone present yesterday, except Senator De La Rosa, voted in favor. So any one of you may move to reconsider the adoption of the resolution.
Would the President agree to a reconsideration therefore of the measure?
I will leave it to the body, not just the Senate President or the Majority Leader. The body will have to agree with that motion. Senator Pimentel is recognized.
Why do we have to go to that extent when I believe the senator only wants to clarify her vote?
That's correct.
Had she been
Aware.
of the voting, she would have abstained.
Yeah,
So,
well, that is
we
precise.
should allow her to make that clarification.
Correct.
And that no longer touch the, go back to the review of the approved resolution.
Correct. That is precisely what Senator Tolentino did. That is exactly what the Senator Tolentino did.
Yes, if that's the case, I'll be very happy to correct the vote as recorded. My vote was in fact an abstention and no vote was made at all. If the
I
President
don't-
will
I
Mr.
don't-
agree.
President, may I ask for a 1-minute suspension?
Session suspended.
Okay naman, ako lang.
Clyde. Yun na nga eh. Oo, oo. Bakit kaya?
Ready to resume, Mr. President.
Session resumed. Before I recognize the majority leader again, just before the break, we would just like to set the record straight, as mentioned by Senator Marcos. Yesterday, there was a quorum. Yesterday, there was a vote. We adopted Senate Resolution 312 sometime in the evening, all right? And the quorum is presumed because no one questioned the quorum when we had 17 senators present. Ano? So, just to set the record, at baka pumasok na naman yung kung sino mag-iisip dyan na we took a vote. We did not take a vote. We took a vote. Nobody asked for a nominal voting. It was merely a motion to adopt. So that is for the record, Majority Leader.
Yes, Mr. President. To add also, Mr. President, we have it's called in parliamentary practice all over the world, including in the House of Representatives and the Senate. That's what we call a continuing quorum. When you establish the quorum in the start of the session until otherwise questioned by a member, you continue your business of the day all the way till the end of the last hour.
Precisely.
Yes, Mr. President. That is standard parliamentary practice. And so yesterday, it was all in order in terms of our procedures, Mr. President. Mr. President, we'd like to recognize Senator Amy Marcos.
Senator
Thank you.
Marcos recognized.
Thank you very much, Mr. President. That being the case, and upon advisement once again of the Majority Leader, may I withdraw therefore the motion to reconsider the measure and instead merely manifest that had I been aware that there was such a motion to approve the said resolution, I would have abstained, given that I in fact have an alternate resolution, number 306, that makes no mention of advisement or pressure upon the President, who clearly has a free hand in the formulation of foreign policy. Thank you very much, Mr. President.
All right, thank you. Place that on record. Senator Pia Cayetano is recognized.
Thank you, Mr. President. Very similar to Senator Marcos, if I was in the hall at the time of the adoption, I would have put on record my abstention. I support a similar view to the resolution filed by Senator Marcos on that does not include specifically advising or urging the President, but just keeping an open mind on our continuing duty to study international conventions, treaties, agreements that affect our country. Thank you, Mr. President.
All right, Senator Cynthia Villar.
I just want to manifest that I was not here when the voting occurred. So if I was voting, I will abstain. Okay, thank you.
All right. Senator Tolentino, Senator Marcos, Senator Cayetano, Senator Bongo is recognized.
The same, if I
Senator
were in the
Villar.
hall, I would also manifest my abstention. Mr. President, clearly each senator is entitled to his or her own personal opinion. Nevertheless, Mr. President, while I respect the views of my fellow senators, I personally believe that as chief executive and chief architect of our foreign policy, it is within his power and prerogative to cause the review and termination of treaties and agreements, taking into consideration the best interests of our sovereign democracy. The President has already expressed his view on the matter, and it is my position that we should respect the President's decision. In any case, we can enter into a new agreement when we have a new President come July 2022. Thank you, Mr. President.
Nevertheless, also for the record, the Presidency and the Senate have our roles in foreign affairs. We represent the same nation, but we can differ in perspectives. And the perspective of the majority of the members of the Senate maintain that we should maintain a cordial relations with friends and allies, just for the record. So we hear that if some of our colleagues who were not here during the vote, 6 would have abstained. Senator Revilla, would you have also abstained?
Yes, Mr. President, I would like to abstain also. Thank you.
7 would have abstained, but there were 17 in the quorum, therefore the resolution would still have been adopted.
20,
All right.
Mr. President, I believe.
20, the quorum was 20.
We're
All right.
20 members
Okay,
of the House.
so majority leader.
Thank you, Mr. President. With that, I move that we dispense with the reading of the journal of the 52nd session Monday, February 10, 2020, and consider the same as approved.
Any objection? Hearing none, journals approved.
Mr. President, I move that we proceed with the reference of business.
Secretary will proceed with reference to business.
Reference of business, bills on first reading. Senate number 1326, entitled An Act Declaring the month of October of every year as the National Cooperative Month in the entire country, introduced by Senator Zubiri.
Referred to the Committee on Cooperatives.
Senate number 1327, an act making the position of a cooperatives officer mandatory in the municipal, city, and provincial levels, amending for the purpose Republic Act number 7160, otherwise known as the Local Government Code of 1991, introduced by Senator Zubiri.
To the Committees on Local Government and Cooperatives.
Senate number 1328, an act declaring the Northern Antique protected seascape and landscape located in the municipalities of Libertad, Pandan, Sebaste, Culasi, and Tibiao in the province of Antique as an ecotourism zone to encourage the responsible and sustainable use as well as for the preservation and conservation of the natural resources found therein, appropriating funds therefore and for other purposes, introduced by Senator Zubiri.
Referred to the Committees on Tourism, Environment, and Finance.
Senate number 1329, an act providing for the protection of financial consumers and for other purposes, introduced by Senator Angara.
To the Committees on Banks and Trade. There is additional reference to business.
Additional reference of business, bill on first reading, Senate number 1330, an act amending Article 183 of Act number 3815 as amended, otherwise known as the Revised Penal Code, introduced by Senator Gordon.
Referred to the Committee on Finance.
Resolution, PS Resolution number 319, entitled Resolution urging the Senate Committee on Finance to conduct an inquiry in aid of legislation on the budgetary appropriations and implementation thereof of the government's industrialization and employment generation initiatives as outlined in Republic Act number 11465, otherwise known as the 2020 General Appropriations Act, introduced by Senator Angara.
To the calendar for ordinary business.
Committee report. Committee report number 44, submitted by the Committee on Trade, Commerce, and Entrepreneurship on Senate number 779, introduced by Senator De Lima, entitled An Act Protecting Consumers and Users Against Forced E-Billing, adding for this purpose a new provision and amending certain provisions of Republic Act number 7394, otherwise known as the Consumer Act of the Philippines, and providing penalties for violations thereof, recommending its approval without amendment, sponsor Senator Pimentel III.
This is referred to the calendar for ordinary business, but the other one, Resolution 319, I stand corrected. It is referred to the Committee on Finance, not yet to the floor.
Thank you, Mr.
Majority
President.
Leader.
Mr. President, we have guests here from Ilocos Norte, our distinguished mayor of the town of Marcos. Mayor Antonio Mariano and his group, Mr. President, officials.
Welcome to the Senate.
Thank you, Mr. President. Mr. President, may we recognize our distinguished Minority Floor Leader for a manifestation for
Senator Frank Drilon, Minority Leader, is recognized.
This is a manifestation directed by the Majority Leader, Mr. President. There is and the Majority Leader has asked me to place on the record the manifestation of Senator Laila de Lima. And let me read that, Mr. President. Quote, "It was reported to me this morning that resolution number 37, or resolution expressing the sense of the Senate for the President to reconsider his plan to withdraw from the Visiting Forces Agreement with the United States of America, in the meantime that the Senate is conducting a thorough review of the same," close quote, has been sponsored by our Chair of the Committee on Foreign Relations, Senator Coco Pimentel, and subsequently adopted by the plenary. I would like to place it on record that I am in support of this measure, and had I been given the opportunity to vote, I would have joined its proponents. In fact, I would even go further as to reiterate my position that treaties concurred by the Senate should likewise require the Senate concurrence before they are abrogated by the President. The fact that there is no urgency which requires a quick unilateral action by the President on the BFA supports our contention that the Senate is an indispensable part of our treaty-making and treaty unmaking process. Much has been said as to aid, assistance, and expertise extended by our defense forces by virtue of this agreement. With ever-present threats to our territory and sovereignty, it would serve our country well to maintain our relationship with our allies, especially the ones who share our values of democracy and human rights. Signed, Senator Laila de Lima. Thank you very much, Mr. President.
All right, he placed the record.
And yes,
Majority
Mr.
Leader.
President, it was not of my doing, it was just that it was a member of the minority. So I asked the Minority Leader to
But
read
the letter was
the
addressed to you.
manifestation.
The letter was addressed to you.
Yes, but I only, from me, I passed it to the Minority Leader because being the Minority
All right.
Leader, he's the leader of his, members of the minority.
All right.
Mr. President,
You still do not want to admit about the presence of Batman and Robin in the
yes,
Senate.
Mr.
huh?
President.
All right.
They might think we are company union. Mr. President, I move to transfer from the calendar of ordinary business to special orders Senate Resolution number 106, 107, 108, 123, and the privileged speech of Senator Gordon on the good conduct time allowance. I so move, Mr. President.
Any objection? Hearing none. So transferred.
Mr. President. Mr. President, I move that we consider the said resolutions and the said committee report.
Any objection? Hearing none. Committee reports hereby considered.
Thank you, Mr. President.
Mr. President, we'll ask the Secretary to read the title of the measure.
Thank you.
Mr. President.
Secretary will read the title of the measure.
Resolution directing the Committee on Justice to conduct an inquiry in aid of legislation into the reported eligibility of Antonio Sanchez for an early release from prison with the end in view of ensuring the proper implementation of and enacting remedial legislation to Republic Act Number 10592.
Majority Leader.
May we recognize the sponsor, Senator Richard?
Sponsor, Chairman of the Committee on Justice and Blue Ribbon, Senator Richard Gordon
Thank you,
of
Mr. President.
Zambales is recognized.
Thank you, Mr. President. With the permission of the President and the Majority Floor Leader, who's under the direction of the Minority Floor Leader, Mr. President, I would like, I really shudder to make a presentation here on good conduct because we have a colleague here who appears not to be. Thank you, Mr. President. Mr. President, esteemed colleagues, the Committee on Justice and Human Rights, Public Accountability of Public Officers and Investigations Blue Ribbon Committee and the Constitutional Amendments and Revision of Codes now sponsored for the consideration of this chamber, Committee Report number 42. The following resolutions relating to the proposed measures were referred to these committees, and these are PS Resolution number 106, introduced by Senator Franklin M. Drilon, entitled Resolution Directing the Committee on Justice and Human Rights to conduct an inquiry in aid of legislation into the reported eligibility of Antonio Sanchez for an early release from prison with the end in view of ensuring the proper implementation of and enacting remedial legislation to the Republic Act number 10592. PS Resolution number 107, introduced by the Senate President himself, Vicente C. Soto III, entitled Resolution Directing the Senate Committees on Justice and Human Rights, Constitutional Amendments, Revision of Codes and Laws, and other appropriate committees to review, in aid of legislation, the implementation of Republic Act number 10592 on Good Conduct Time Allowance, or GCTA, with the end in view of amending the same in order to ensure that those prisoners who truly deserve the law's benefit shall be granted of the same. PS Resolution 108, introduced by Senator Maria Lourdes Nancy S. Binay, entitled Resolution Directing the Appropriate Senate Committees to conduct an inquiry in aid of legislation on the implementation of Republic Act 10592, particularly the computation of the good conduct allowances of persons deprived of liberty in light of the impending release of 11,000 inmates due to the revision of the computation of GCTA and its retroactive application. PS number 123, introduced by Senator Ronald De La Rosa, Mr. President, entitled Resolution Urging the Department of Justice and Department of Interior and Local Government to review, amend, and modify the issued implementing rules and regulations of Republic Act number 10592 to reflect the legislative intent of the Congress with the end in view of upholding the impartial delivery of justice. The privileged speech on the good conduct time allowance of yours truly, Senator Richard Gordon, delivered on August 27, 2019, and motu proprio by the Committee on Accountability of Public Officers and Investigations, invocation by the Blue Ribbon Committee, Chairman of Rule 10, Section 13 of the Senate Rules, that the Blue Ribbon Committee may undertake an investigation on any matter of public interest on its own initiative or motu proprio. TSN dated September 2, 2019, page 3. Now, Mr. President, before I continue, I would like just to say, state a caveat. This will be our second partial report, Mr. President, regarding the good conduct time allowance. Now, Mr. President, even at an early age, most of us, if not all of us, have been exposed to what life in prison is. Either through the movies or through stories. We may not have been confined in prisons ourselves. We may not even know someone who had experienced incarceration, but literature and our films have depicted to us the repugnant conditions and horror of prison life. One cannot forget Edmond Dante, Count of Monte Cristo, and his captivity at Chateau d'If, and how dreadful the conditions were at that prison. There is also the portrayal of horrific conditions in hot and humid Ile de Diable that we read in Papillon, Henri Charrier. Their prisoners were subject to torture, disease, malnutrition, and the debasement of humanity. Hindi tayo kailangan pang lumayo, Mr. President. Napanood natin ang pelikulang On the Job, kung saan pinapakita ang mga preso na ginagamit sa pagpatay ng mga taong labas. Hindi sila mapagsuspetsahan dahil nga naman sila ay mga detenido. I don't have to see that movie, Mr. President. My family has been a victim of that. Prisoners were allowed to escape on all the attempts against my father. On 3 occasions, they were allowed to escape. Fortunately, they were captured. Unfortunately, in our country, there is no closure. The masterminds have not been captured. But what is important to note is that imprisonment is horror, fear, and terror rolled many times over. This is not to say those who are inside do not deserve to be there. They must pay for their crimes. But those who get to be inside, given their vulnerability, are prime candidates or subjects for extortion, exploitation, intimidation, and deprivation, Mr. President. That is a given. The New Bilibid prison became a place, such a place, Mr. President. Excuse me. Of vulnerability. The New Bilibid prison has become a place, such a place of vulnerability, Mr. President. And for that matter, even our detention centers. They have become places upon which prisoners are exploited, intimidated, even their families are exploited and even harassed sexually by the guards or by people in authority in the prisons. Persons deprived of liberty, while they deserve to be in prison because of their crimes, do not mean that they should be exploited and be taken advantage of. Their vulnerable situation makes them prone to the many extortions and the many pressures and intimidations done inside the Bilibid. You can take a look at the slide and you can see the squalid conditions in our prison. When our PDLs walk into the Bilibid, they face a lot of temptations, not just exploitation. As we have uncovered during our hearings, we saw that there have been several activities being done inside the Bilibid. These are nefarious activities, to say the least. There is a sale of the good conduct time allowance. Entrepreneurial, yung mga ibang papatakbo ng preso. Ibinebenta yung good conduct time allowance. At kung di ka susunod, wala kang good conduct time allowance. May blackmail ka. There's a sale of hospital confinement passes. Pagka gusto mo ma-hospital para makapunta ka lang doon, kailangan meron kang passes. Babayad ka. Kung gusto mo lumabas, depende kung gaano ka kalaking tao, makakabayad ka as much as millions of pesos para tumagal ka sa labas on the guise that you are sick and that the prison cannot take care of you. Kubols are still prevalent. I mean, just recently there was another raid and again cell phones were confiscated along with other contrabands. And there are contrabands, cash, cell phones, drugs found in the New Bilibid prison. Tilapia is staple food by the poor. Here, tilapia is prostitution in the NPP. Pag pumasok ka dyan, pwede kang dalahan ng tilapia. Ibig sabihin, pag nagbayad ka, there is course prostitution being undertaken by those who are influential in prison. Even catering, alleged favoring of caterers in the Bucor, where the budget assigned to feed the prisoners are excessively reduced so that people can make some more money on that. How can our PDLs be reformed if they are subject to these temptations, extortions, intimidations, and exploitations? Under the Mandela rules, even the persons deprived of liberty deserve to be respected. We're all aware of Nelson Mandela, who was in prison for more than 30 years in South Africa. And because of his freedom, he was able to come out with some form of prison reform. Rule 2, Paragraph 1 of the United Nations Standard Minimum Rules for the Treatment of Prisoners of the Nelson Mandela Rule provides, the present rules, and I quote, shall be applied impartiality. There shall be no discrimination on the grounds of race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or any other status. The religious beliefs and moral precepts of prisoners shall be respected. Mr. President, there must be a model system of penology, and there must be a consistent effort to try and create that model. There should be, for example, full digitalization of the carpetas, which should be accessible to the public or the families of the concerned parties. More often, the carpetas are hidden, and are used as threats to make sure that sometimes they stay more than the time allocated, or they follow what they do not want to do, but because of the carpeta, they could be punished severely. That's why we require transparency, especially with regard to the computation of time allowances and release of prisoners. Full digitalization of all prisoner records is a must. The public must have access to the possible release dates of the PDLs. In addition, The records of Bucor and BJMP employees and personnel should also be digitalized for easy monitoring and filing, and also to make sure that we are getting the right mix of security personnel among the employees of those institutions. The new Bilibid Hospital should be maintained, given a right budget, and be well equipped with adequate medical services so that it doesn't become an opportunity for money made by the powerful in the Bilibid. The DOJ must conduct a thorough investigation of the confinement at the new Bilibid Hospital and other hospitals of drug convicts and high-profile inmates. The DOJ must institute guidelines to ensure that only those with actual sickness and diseases are confined in hospitals. Proper monitoring should be undertaken. If it's digitalized, it can easily be monitored. There should be and like I said, a strict monitoring of those PDLs confined in the hospital will ensure that they are not using their confinement as a medium for their illegal business transactions. There should be an operations center which can monitor every prisoner. The moment that the PDL is released, the Department of Justice must be informed immediately. The use of artificial intelligence, digital and video analytics with command center independent from each other inside our prison facilities is a must. This would ensure that the PDLs, guards, employees are constantly monitored. Funds should be provided as suggested by the other senators. There should also be a code of conduct that is strictly followed. Now, the results of the Senate investigation are as follows, Mr. President. Because of our hearings, the DOJ and the DLE issued a revised IRR on September 16, 2019. This clarified that those convicted of heinous crimes cannot avail of the good conduct time allowance. 2, it resulted in the rearrest of heinous crimes convicts. On September 4, 2019, the President, Rodrigo Roa Duterte, ordered heinous crimes convicts to surrender to authorities within 15 days. That's swift action, Mr. President. Bucor Director General Faildon was fired by President Duterte for the second time, first as customs, and he was moved here, and he did not take opportunity of the second chance given to him. Also, at the same date, on September 4, 2019, President Duterte announced that he demanded the immediate resignation of Nicanor Faildon. The Ninja Cups, investigation on the Ninja Cups, which already submitted a partial separate report, Mr. President, because it went all the way outside because of its connectivities inside. The Bucor Alas is manned by rotten apples and corrupt officials. Not all, but mostly. It is rotten to the core and from top to bottom. Excuse me. If we are to improve its functions, if we are to have the Bureau regain the trust of our people, no less than a massive change in personnel and in character is required. Mere lancing of the boil will not be sufficient. Putrefaction in that agency is so far so advanced. Only a total replacement of the whole bureaucracy will allow us to see a new, honest, sincere, serious, and effective agency. Now, with respect to the acts of Nicanor Faildon, he admitted that he did not know the existence of Department Order Number 953. He did not follow the requirements under DO 953, such as prior approval of the Secretary of Justice before the releasing of national prisoners sentenced to life imprisonment, reclusion perpetua, or high-risk inmates. Furnishing the Secretary of Justice, he failed with a list of inmates due to be released at least 1 month before their expected date of release. Issuing a certificate as to the correctness and accuracy of the computation of the credits granted and expiration of sentence of the prisoners affected. As it is, Mr. President, we're all aware that the Sandigan Bayan has already ordered the filing of cases, for that matter, the dismissal of some of the officials involved in the computation of sentences. He only verbally recalled the memorandum order of release of former Mayor Sanchez. Yet it seems clear that there was a prior agreement between Faildon and the family of Mayor Sanchez. As seen in various news reports, the family of former Mayor Sanchez were confident that former Mayor Sanchez would be entitled to the GCTA and would be able to walk free. The family knew that he was prisoner number 187. They already had plans to bring Mayor Sanchez to eat at his favorite Japanese restaurant in Makati. They had plans to visit an eye clinic for his cataract problem. In an Inquirer video, one of his sons, Alan, mentioned to Faeldon that, and I quote, "Sir, nag-usap po tayo. Nangako kayo. According to GCTA, isa siya sa qualified." Close quotes. His other son, Anthony, mentioned that they were already being congratulated for the impending release of their father, not to mention the fact that the wife of Colonel Faeldon, or Captain Faeldon, was able to go in and out of prison, especially when they found out that something was amiss. They could go out at night and visit Mr. Faeldon, and the following morning also was entertained again. Now, therefore, we recommend the filing of cases against the following people, Mr. President. Nicanor Faeldon for nonfeasance, did not allow the procedures requirements of DO number 953 to be implemented. Ramoncito Chito Roque, already given some form of punishment with the Ombudsman. Good for him. Chief of the Documents and Records Section of Bucor. Maria Benilda Mabel Bansil, Corrections Senior Inspector, Bureau of Corrections. And Veronica Boday Buno, no relation to Bono, Correction Officer, Bureau of Corrections. Malfeasance, accepting money for the promise of early release of prisoners. Dr. Ernesto Tamayo, Director, Directorate for Health Services, New Bilibid Prison Hospital. Dr. Ursico Dicenas, Medical Officer, New Bilibid Prison Hospital. And Ms. Meryl Benitez, Nursing Attendant, New Bilibid Prisoners, New Bilibid Prison Hospital. Malfeasance, accepting money in order for the PDLs to be confined in the New Bilibid Prison Hospital, and also allowing certain personalities to go to a private hospital for an extended period of time upon payment of the right price, Mr. President. Now, Mr. President, at this point, I just want to point out that there have been continuous deaths and killings of Bureau of Corrections officers employed since 2011. In fact, 12 of them have been killed, Mr. President. There have been recent killings, and they have been done through riding in tandem. And before I end, Mr. President, we acknowledge the invaluable contribution of Senate President Soto, who brought Mr. Godfrey Gamboa and Ms. Yolanda Camilon, whose testimony allowed us to give us a clearer and truthful picture of the horrors inside. Now, Mr. President, this is the partial report, as I mentioned, and I would like to ask that the Senate approve this partial report, Mr. President. Thank you very much, Mr. President. And I'm ready to accept any questions.
Majority Leader.
Thank you, Mr. President. Mr. President, just to clarify for the record that since they're still continuing with the investigation, therefore it's a motion to adopt the second partial report, Mr. President. That is the proper motion. So I move to adopt the second partial report of the said committee. I so move, Mr. President.
Any objection? Hearing none, the second partial committee report is hereby adopted.
Thank you, Mr. President. Thank you, colleagues.
Walang kamatayang committee investigation. Walang kamatayang.
May I just make one more comment, Mr. President?
Yes, Senator Gordon.
We thank the Honorable President Duterte for his quick action on the matter of accepting the resignation and overhauling right away the Bureau of Prisons with a new director of the Bureau of Prisons. And we also thank the Senate for the approval of our bill on the new prisons that are for high value prisoners, Mr. President. Thank you very much, Mr. President.
Majority Leader.
Thank you, Mr. President. Mr. President, with that, to other matters, Mr. President, with the consent of the body, I move for the Senate President's designation of the Joint Senate, or the Senate panel to the Joint Congressional Oversight Committee on Public Expenditures pursuant to Section 96 of Republic Act 11465, or the GAA of fiscal year 2020. So I believe it's your designation, Mr. President. There are 8 names here.
This is a joint congressional oversight committee. Therefore, we are designating our chairman of finance to be the co-chair.
That's correct, Mr. President.
Senator Angara to be the co-chair. And members Cayetano, Gatchalian, Go, Gordon, Villanueva, Villar, and Rilon.
That's correct, Mr. President.
So designated.
Mr. President, there are just a few local bills in line for sponsorship. Mr. President, I move that we transfer the calendar ordinary business to special order, House Bill number 4961. So moved, Mr. President.
Any objection? Hearing none, so transferred.
Mr. President, I move that we consider House Bill number 4961.
Any objection? Hearing none, consideration is in order.
Mr. President, may we recognize the sponsor, Senator Francis Tolentino.
Senator Francis Tolentino is recognized to sponsor House Bill
May I ask
4961
the-
after the Secretary will
Secretary
read
reads
the
the title.
title of the measure.
An act creating a barangay to be known as Barangay H2 in the city of Dasmariñas, province of Cavite.
Chairman of the Committee on Local Governments recognized.
Mr. President, considering the passion generated by the adoption of Senate Resolution 312, and to enable our colleagues to allow the parliamentary passion to subside and for other matters to be tackled, I move that my sponsorship speech on Committee Report 38 be just inserted into the record, Mr. President.
All right, any objection? Hearing none, so inserted.
Thank you, Mr. President.
Thank you,
The
Mr. President.
Majority Leader.
Mr. President, to allow our colleagues to study the measure, further we move to suspend consideration of the measure.
Any objection? Hearing none, consideration of the measure suspended.
Mr. President, I move that we transfer the calendar ordinary business to special order, House Bill number 2998.
Any objection? Hearing none, transfer is adopted.
Mr. President, I move to
Approved.
consider House Bill number 299 as the Secretary to be the title of the measure.
Hearing no objection, consideration is in order. Secretary will read the title of the measure.
An act transferring the capital and seat of government of the province of Rizal from the city of Pasig, Metro Manila to the city of Antipolo, province of Rizal.
Majority Leader.
May we recognize the sponsor, Mr. President, the chairman of the committee, Senator Tolentino.
Senator Francis Tolentino, Chairman of the Committee on Local Governments, recognized.
Mr. President, my esteemed colleagues in the Senate, good afternoon. It is with great honor that I submit House Bill 2998, taking into account Senate Bill 1170 of Senator Ramon Revilla Jr. for consideration of this chamber as our country enters into a new decade, passing the act transferring the capital and seat of the government of the province of Rizal from the city of Pasig, Metro Manila, to the city of Antipolo, province of Rizal, has become more pressing given that it will be 45 years since Pasig was ceased to be part of the Rizal province by virtue of Presidential Decree 824. Sufficient it to say, as can be gleaned from the title of the act itself, the current capital of Rizal province is a city not even within Rizal's jurisdiction. Curative legislation has been repeatedly sought in the 16th and 17th Congresses, and in both instances, the bill reached the third and final reading in the House, but failed to move because of lack of material time. The transfer of the seat of government is not without legal imprimatur. Section 11 and 12 of the Local Government Code authorizes local government units to transfer the seat of government, Mr. President, after certain conditions are met. In this regard, a resolution was adopted by the Sangguniang Panlalawigan of Rizal way back in 2013, calling on the House to declare the city of Antipolo as the capital of Rizal. Verily, Mr. President, Antipolo has been functioning as the de facto seat of government of the province of Rizal, and the only formal baptism of legislation is lacking to solidify its position. Antipolo City has been housing the provincial offices in the Inares Center complex since 2007. Moreover, the city of Pasig has expressed its support for the measure. In a position paper which was reaffirmed in our recent committee hearings, it stated that it is but right that the capital of the province must be a city within the jurisdiction of Rizal and not Pasig City, which is already outside the jurisdiction of Rizal Province. In sum, the fundamental change in circumstances brought about by Pasig's transfer to Metro Manila could not have been foreseen nor prevented by the province of Rizal and should not remain as an impediment for the enjoyment of its right of self-determination. In the interest of efficiency, administrative efficiency, this measure will ultimately rectify the legal inconsistency brought about by Presidential Decree 824. Lastly, let me end my sponsorship speech with the Latin maxim, tempora mutantur nos et mutantur in illes, or times change, Mr. President. Times change, we also change with them, unquote. Today, this humble representation urges this august chamber to heed the appeal of the people of Rizal. Let it be during the 18th Congress that this measure will be finally passed. Salamat po, Mr. President.
Majority Leader.
Yes, move to suspend consideration of the measure, Mr. President, while
Any
our colleagues to
objection?
study the measure.
Hearing none, consideration of the measure is suspended.
There's one other item on the agenda, but if you wish, Mr. President, we do take a restroom break. We'll move for a 1-minute Senate
Well,
suspension.
thank you. That will be most welcome.
Thank you, Mr. President. I so
Session suspended for a few minutes.
Ano muna kami? CR break. Ano? I'm going to find a May ano pa ba? Meron pa bang additional reference of business? Ready to resume, Mr. President?
Session resumed.
President, we just have additional reference of business. I move for the additional reference.
Secretary will proceed with the reference with second additional.
Second additional reference of business, bill on first reading, Senate number 1331, entitled An Act Institutionalizing the Practice of Extended Producer's Responsibility in Waste Management, amending for this purpose Republic Act number 9003, otherwise known as the Ecological Solid Waste Management Act of 2000, introduced by Senator Villar.
Referred to Committees on Environment and Finance.
Resolution, PS Resolution number 320, entitled Resolution Directing the Senate Committee on Youth to evaluate the efficacy of all existing government programs for the youth with the end in view of determining its implementation and overall effect to its beneficiaries, introduced by Senator Angara.
Referred to the Committee on Youth.
Thank you, Mr. President. The other matters will, under our agenda, will be taken up tomorrow, Mr. President, as requested by these sponsors. Mr. President, with that, I move that we adjourn session until 3 o'clock in the afternoon, Wednesday, February 12, 2020. I suppose.
Any objection? Hearing none,